support this statute. I say this to you because I want you to be thinking about these issues in regard to we are in a federal versus states' right environment again now. And so that's part of that the states, certain states, for example, are challenging, and I think I mentioned this to you before, abortion. And they're saying the federal government, they're trying to overturn abortion. Like, here's how they might do it. We are going to put the doctor in jail that performs the abortion. They pass a law like that. And of course, there's the ACLU, there are entities and advocates, you know, on the side that abortion should be a constitutional right because it's part of, what is it part of? Privacy, which is part of liberty. And I think I may have mentioned that to you before, because you may wonder, well, the word abortion's not in the Constitution. Of course not. But that was the reasoning of the Supreme Court in Roe versus Wade. Many states, including Pennsylvania, there's huge numbers of states that are passing laws to make abortion much more difficult, and also to try and lessen the impact of the Civil Rights Act. All right, so we're going to focus on, and there's sports also, by the way. There are sports issues. And I don't know if you saw the famous soccer player, female soccer player. Oh gosh, she really helped us win at the Olympics. She's got very short hair. Anyway, if you look up, I think her last name is Rapinoe, maybe something. Do any of you know who I mean?
Megan Rapinoe.
Megan Rapinoe, thank you. Who said that?
Autumn.
Autumn. Oh, there you are, Autumn. Okay, yes. And so she was at the White House yesterday talking to Joe Biden once again about the discrimination of the funding of the female teams that represent us in the Olympics versus the male teams. And I don't know if you saw, there was a news item within the last month that they showed the workout room for the female Olympic team. And it was like this tiny little room with 2 sets of weights or something. And then they showed the one the men had. And I think that they, the women were objecting. And I think they have gotten a better workout space. Autumn, have you followed that at all?
I think you're talking about the NCAA March Madness tournament.
Well, there's that too. Yes, was that? Yes, I think you're right. That's what it was with the workout rooms.
Yeah, they ended up upgrading their workout room. It's better now.
Yes, it's better now. That's right. Because under the NCAA, there's not supposed to be what? Discriminatory treatment on the basis of gender or race. All right. So there are lots of issues that go on in terms of equal treatment in sports and public accommodations. There's all these different quote sections or titles, which are sections of the Civil Rights Act of 1964. We are going, I just tell you that for your general knowledge. It will inform as you watch the news if you see items about things like this. But in our employment section, Title VII, the purpose is to create, now we saw this in securities law, a level playing field, right? In employment decisions based on merit. Nowhere in the legislative purpose of the Civil Rights Act does it say we want employers hiring unqualified people. Not in any of the cases, not in the legislative purpose. But, right, as many of us may be minorities, we have to think as we go through this, right, that it means equal for everyone, and that includes white men. The white men are not all bad here. I've got one sitting in the other room that I'm very fond of. And of course, all of my students as well. So That's why we'll see if we can get to affirmative action, some of the issues that are there. All right, employment decisions, covered entities, all companies. That was challenged, as I mentioned, but in employment as well as in public accommodation, and it became clear all companies must abide by the employment requirements of the Civil Rights Act of 1964. Now, generally, I do want to say to you, as I try to emphasize, that it does not mean employers need to hire the unqualified. But we have to make sure as a society, everyone has equal access to obtaining the qualifications, be it education, vocational education, or what have you. All right. So clearly, race was one of the protected classes because that's one of the areas where there had been a big problem. Also, color, ethnicity, right? Is it okay to discriminate, right, against, for example, Muslim young men because there was a Muslim young man that engaged in the shooting in Colorado, right? So sometimes ethnicity can be the basis of discrimination. And now gender. I have to tell you one last thing that the southern states tried to do. So the statute's there. The Supreme Court is upholding it as constitutional. Okay, so now we come to when they're writing the bill. The southern states say, you know what we'll do to defeat it? We'll put gender in. Nobody, none of the senators or congressmen will vote for a statute where gender is part of it, meaning equality for women. Who needs that? So they threw it in. Obviously, it was adopted, but there's no legislative purpose or history. And so virtually all of the gender decisions have been court law. There's an upcoming slide on that. A lot of them going all the way to the Supreme Court. So if you look at the Civil Rights Act, there is no mention of the words sexual harassment. Now in state statutes, there are, and we have a liberal state statute that's similar, analogous to the Civil Rights of 1964. It's through our Department of Fair Employment and Housing, right? Because another area of discrimination historically had been in housing.
Professor, I have a question.
Yes.
So for people who are like born biracial, is it almost somewhat unethical for them to, like when they're applying to colleges or businesses, to check the box sometimes to be African American and then sometimes to be white, based on what advantage they would get from that?
Well, that's a very interesting question. I think I need to know more about the facts. I will also tell you, so that you know kind of where I'm coming from, is that I am part of a biracial family. My niece and nephew are half Korean.
Yeah, so I'm the only white guy in my family, and
Go ahead.
African American box when I'm applying to college. But any other time I would usually just mark that I'm white because there would be a whole lot of explaining to do.
Right. Well, I have to think about that. Obviously, it's not a lie, right?
Yeah.
So there's not that wrong of the lie. It's more using opportunity to your advantage. So, you know, I think as long as the underlying information is not a lie, that, you know, I wouldn't recommend someone do it, but I don't think it's a huge ethical wrong either. And I have two godsons that are half Black, and how they are treated back in Ohio compared to whatever wrongs go on in California, you know, Ohio tends to be a pretty racist state in its treatment of minorities. All right. So we'll talk about gender more, but you know that gender and sexual harassment and everything we're going to get into came up through Supreme Court interpretation of cases that were filed. Don't forget in this area that we are going to see that there are organizations that are supporting the plaintiffs, whether it was Roe in Roe versus Wade, or whether, and Wade was the Secretary of State of Texas who made abortion illegal. In fact, the woman in Roe versus Wade, who's since come forward and identified herself, never had an abortion because it was against the law in Texas. So she had that baby, which is just an interesting twist. That's a very interesting case. All right. So what decisions are covered? Everything about employment, hiring, promoting, firing, all employment decisions. Now, I want to point something out to you about the hiring, right? As I said to you in the law, usually the law does not penalize someone for not doing something. Usually the law penalizes you for doing something wrong. But here, the not hiring of certain individuals who are qualified, right? I know there's a lot of confusion out there thinking, oh, we have to hire unqualified individuals, but that should not be. That's not going to help anyone in the longer run. What we need to do is address this in education and so forth. Okay. I don't know if I told you, I think I told my other class. Do any of you know the Freedom Riders? It came through the Long Beach School District, through Wilson High, I think.
Yeah.
And Aaron Gruel came and spoke to the students in my ethical leadership class. And all of a sudden, it just struck me like a thunderbolt that when I do retire, I would like to volunteer for her and have some impact on education earlier in the system. Okay, any questions so far? So let's consider the not hiring. I'm giving you the actual terms in the cases, but here's the only word you really need to know, because I'm not trying to trip you up on the actual terminology, but rather have you understand the concept. There is intentional discrimination. Those cases where it said no women need apply, no blacks need apply, all of that was intentional discrimination. One of the cases we're going to talk about, and one of my 3 daughters worked there in a minute, is Abercrombie and Fitch. You guys know Abercrombie and Fitch. Is that store still around? The one near me went out of business. So I have to tell you a funny Abercrombie and Fitch story. So they used to have these huge things in the window. I don't know if they still do, like they'd have a very buff young man with almost no shirt on or shirt open or something like that. So my daughter that works for Abercrombie brings this home and puts it in her bedroom, this huge sign. And oh, my husband was not thrilled with that. But there it sat in our home for a number of years. When she moved out, we threw it out. But I say that to emphasize that there's been a strong emphasis in Abercrombie on a certain look, what they're really advertising is a certain look. And they're not the only ones that do that. And if you are advertising a certain look, is that discriminatory? Anyway, there's a famous case with about wearing a hijab. Does anyone know? Am I pronouncing that correctly? Hijab, which is not a burqa that covers everything and only the eyes are there, but is the head covering. Okay, I have worn hijabs out of respect when I've entered mosques in other countries. Okay, so an intentional discrimination, if it can be proved, you basically win your case. Unless, and here is the employer's defense. So for number 3, put, what is the employer's defense in these cases? That it's a bona fide, this is the legal term, which means genuine occupation qualification. All right, let's take this. It's a store, and the women's dressing rooms, let's imagine it's Victoria's Secret, and there's a male employee who's helping the women in the dressing rooms. Women feel uncomfortable with that, and they ask Victoria's Secret to only have female employees checking to see how their bra fits and so forth. Do you think that would be, it would be an intentional discrimination? They would be choosing the female employees. Now, it wouldn't mean that there could be no male employees, but maybe just not in the dressing room. Do you think that would be a genuine occupation qualification? Ashley, anyone? Any thoughts?
Yes. Well, it's because they are trying to protect from sexual harassment or from like their customers feeling uncomfortable. But fully excluding men, I feel like would not go with the BFOQ. But actually choosing women for helping women customers, then I feel like that can be genuine.
Mm-hmm.
Yeah.
Any other thoughts?
Isn't
Opinions? These are the kinds of cases that come up.
isn't like Victoria's, that's like a women's like lingerie store, right? Or something.
Correct. That's why I specifically, and there have been cases about this involving Victoria's Secret, but yes. So,
Wouldn't it make more sense to just have like, I feel like that's like one store that you would have a all female, employment.
well, they have to hire males or it would be discriminatory. But if the female customers prefer when they're in the dressing rooms, changing, trying bras on and things like that, that a female help them, then that may be a BFOQ.
Well, it makes more sense to have a female help them because it's like, what would I know about wearing a bra?
Okay, that's another BFOQ, Malcolm. Very good. That's right. How are you going to judge the fit, right?
Well, I worked at a retail store, and we have a rule that we don't let any men into a fitting room. They have to go to a separate fitting room. But when the line gets blurry is when the male sees itself differently. And there's been many times where the male wants to be known something else, like either gay or anything else. And I work in the teen department during that time, and it was really hard to tell the person, sorry, because you're not a woman, you can't go inside. But from the customer point of view, I can see how it's more discriminative, but yes.
That's an excellent example, Ashley. I will have to look at that because we are moving to a society. I don't have it up on mine yet, but you may notice that a number of individuals, and my sister, who's a high-level attorney in the federal government for environmental law, the women that report to her, the female lawyers, all feel strongly. And so they'll identify, right? She, her, hers. And I've had students that identify that if I looked at them, I might think one thing, but their identification would be something else. So I think that's a whole new area. I think you raise an excellent issue, Ashley. But I think that ultimately, the customer's preferences would be, part of the BFOQ. And they may still, because they perceive the individual to be a male. It would depend. I will always remember my children were young and we were in Vienna, my daughters, and we were at a ballet or something, and we went in the ladies' room at break. And all of a sudden my daughters were all in a fluster and they were going, Mama, Mom, the feet are pointing the other way. And they could not get out of that bathroom fast enough. So that generated, of course, after the performance, a whole discussion of, right, who uses what bathroom, gender neutral bathrooms, things like that. That's a huge issue right now. In Europe, that was very acceptable. And that was a long time ago. That was 20 years ago. So sometimes culture can impact what we perceive to be gender and the definition of gender. All right, other defenses include seniority. You can make, right? You can intentionally discriminate and say, okay, our system is seniority, and so the most senior person is going to be the one that gets promoted. Genuine job performance or additional qualifications. What if you have two engineers at Boeing or any of the aerospace companies around here, and one goes and gets an MBA and one has just the undergraduate engineering degree, and there's an opportunity to promote into management, right? So would it be okay, even though the person happens to be a white male, to promote the white male into management first because he has the MBA? So you can see these decisions come up all the time in employment. You may have been impacted by some of these decisions. Denny is pointing out to us today that he feels that he has. All right. So let's look at the Abercrombie and Fitch case, right? Now, this is a big case. It went to the Supreme Court on the basis, is it discriminatory to have a dress code where a female employee cannot wear religious garb, such as a hijab? The Supreme Court ultimately found that she had the right to wear that, and it was discriminatory. So you can see that there's gray lines, like we're advertising that we're this, but anyway, we're advertising that we're this, but we don't want anyone that doesn't look like that to work for us, right? That would be a discriminatory policy. And as a matter of fact, in the store in which my daughter worked, there were no minorities. So this was a very important case because it also includes what? Religion, right? So it's employment, but it also is touching on religious practices. And religion is covered by the 1964 Civil Rights Act. You can look this case up. I think I have an article that I'll post for you. Any questions on the fact about religion and dress codes? Now let's imagine that instead of an Abercrombie and Fitch, the female wearing the hijab was going to be, thank you, sweetie, in a job where the hijab could create a safety issue. Would it be discriminatory then to say that if she needs to wear it, they can't hire her? What do you think, Nicholas?
Affect a hijab could affect safety wise.
Well, I'm creating, somewhat of a ridiculous hypothetical. But the purpose is to say that, dress code, if it's just for appearance, could be discriminatory. But if you have to make dress code decisions for safety purposes in an assembly plant or somewhere like that, then that might not be discriminatory.
Yeah, it's just like how they make people put their hair, if you have long hair, put it up in a hairnet or something like that for like a
That's right.
sanitary issue.
And I told you about my first case in workers' compensation, where that young girl got her long hair caught in a picking machine in the fields. And so, that had tremendous impact and does on me to this day in terms of workplace safety issues. But yes, so, that would be a BFOQ of safety. We're going to get into that in a moment in terms of language and proficiency in English, and requiring that, is it discriminatory or not?
I have a question.
Yes, Campbell?
So I work in the restaurant industry, and like in our booklet that they give us, they
Yes.
say men are not allowed to have their ears pierced, but women are. They don't enforce it, but because it's a corporation, but like it does say that. Do you think that's legal or no?
Well, here's the thing. It gets complicated because there's one group that is not covered by this statute. What group is it?
Religious?
No, white males. That's
Wait,
why,
what?
because white males historically, if you go back to the purpose, and I should have explained this earlier. If you go back to the purpose of the statute, and this is one of the stated in the case law purposes of affirmative action, right? When we started and we said there's got to be equal opportunity, not equal jobs, equal opportunity. Okay. But there were certain groups that were already way behind, weren't they? So day one, you say, okay, now we're going to make it equal, but it can't be equal because there were groups that were already way behind in terms of the qualified number of individuals that could, potentially be in the workplace. So white males, if it was a religious issue, they could be covered, but they'd be covered for religion. However, there could also be gender issues with the earring issue. If I were their HR advisor, I would advise them to take that out.
Yeah, luckily they don't enforce it, but it does say it.
Yeah. So that's not a good idea, I think. But it would be hard, maybe all males could bring it as in regard to equal opportunity. I don't know. I'd have to think about that because specifically white males are not covered by this statute. Now, with affirmative action, it's not meant to go on forever. At some point, the historically discriminated against groups will move forward. That was the hope in 1964. And certainly we have made progress. Certainly I can see in the California State University system, and that's why I'm so happy to teach here versus a private school. I've had offers from private school, but we still have work to do. And I think a big part of it is going back to the resources of our, quote, inner city schools, elementary, middle, and high schools. And, what kinds of teachers are they getting? What kinds of education are they getting? All right. So now we're going to call this one unintentional, even though it's called disparate impact analysis. I will tell you one thing. This is very statistically based. The cases usually have statistical experts on both sides of the case, right? So there's an employer hiring a protected class, right? But it results in a lower percentage of that class in the local labor market. So that gets back to what Denny brought up at the very beginning, right? Certain firms have been told, look, in the Long Beach area or the Los Angeles area, whatever that it may be, we have a unique thing that not every state or city has. We have a very high percentage of Hispanic population. And so are they being represented when they have qualifications to the degree of what the overall society is, the local labor market, are they being represented approximately to that level in local employers? Do you understand that? So we'll make an example. Let's say it's the Long Beach employers involved, and let's say our community. Does anyone know what is the Hispanic population in Long Beach? It's very high. I should ask my student that works for, she used to work for Mayor Robert Garcia, and now she works for Lena Gonzalez. But let's imagine it's 40%, somewhere between 40 and 60% at least, right?
It's 207,000.
And does it say anything about percentage?
I can't get a percentage at the moment.
Thank you for looking, Denny. I appreciate that very much. But that's the basic idea, okay? That now, does this mean that an employer is going to be sued for discrimination and have to pay a lot of money because they didn't hire unqualified people? No, notice it says the qualified pool. Qualified pool. So they can, because qualifications can be behavioral. Now, you may feel differently than I do. I completely respect your opinion. In my opinion, and I've given my life to educating in this way, you know, we need to try and raise everyone's access to getting the qualifications, be it a university degree or what have you. Oh, and by the way, I did want to say this because I said in case anyone wanted to become a professor down the line and wanted to talk about it. Also, as you know, I have a law degree from USC, and I have had many former students go to law school. So if that's in your mind in any way, come to office hours and we can talk about that. I'm happy to be a mentor, write letters of recommendation and so forth. All right, so we have intentional discrimination and unintentional discrimination. Okay, now let me see. Well, let me see where that, because of the wait a minute before we get there. I thought I had, we're not going to get to sexual harassment today. I thought I had put in here, I will add, I'm going to post the BMW case. Let me, we'll stop here. I will post these slides, the BMW case. I want you to read the BMW case, all right? Let me lay out the facts a little bit and the issues that I want you thinking about. BMW had a assembly plant in, we'll say, South Carolina. And they changed their policy and said, we don't want any former felons working for us. They had Black employees that had worked there 20 years, 25 years, done a good job, but they had made a mistake in their youth and had something on their record, right? Is it discriminatory? So it was felonies. It didn't say anything about Blacks, but was felony a surrogate for Blacks. So I will post the BMW case. I will post this. I'll post the Abercrombie case. I'll post a few of them, and we will move on next time to some of the specifics of the statute, so you know to protect yourself, and to talking about when. I also want you thinking about this. When is English, fluency in English as a job requirement potentially discriminatory, and when would it be okay? And I'll tell you a policy based on what Target does about that. Does anybody work for Target? Okay. All right, students, have a wonderful spring break. I hope that you are able to enjoy yourselves. I hope you're able to get away from stress one way or another so that we come back refreshed for the rest of the semester, okay? Be safe, have fun.
Thank you,
Bye.
Professor. Have a good break.
Thank you.
Thank you, Professor.